I am an attorney at Bricker Graydon. I have been doing school law since about 2000. So it boggles my mind to think about the fact that I've been doing this for 25 years. We are here today to talk about two topics. There will be a break in the middle where you will be able to refill your coffee cup, or perhaps, return a single email. But we do have two topics that come from the operating standards. I will be talking about confidentiality in our first half together. And then I'm going to talk about procedural safeguards and really focus on one of my favorite procedural safeguards ever, prior written notice. In particular, we will be focusing on that. And I know you all are groaning thinking, who says that prior written notice is her favorite procedural safeguard? But by the time we're done, maybe I will have convinced you as well, and it will become your favorite procedural safeguard. So I welcome questions. You can throw those in the chat. I may be able to answer those on the fly. And if not, I have some friends from the SST that are monitoring the chat and can interrupt me and let me know at the appropriate time when there's a question. So without further ado, let's get started today on confidentiality. So like all things with students, if you take a look at this first slide, you should think that this is a really highly regulated area. People sometimes ask me, what did I know I wanted to do school law? And the answer is like, are you kidding me? When I went to law school, there wasn't even an education law course. And now I, work in an industry where I would say we are one of the most regulated industries. There is a law covering everything, and then there's a regulation, and there's a state and a federal law. And so that's essentially what this slide is giving you. It's giving you the overview of what controls when we're talking about education records. So for all students, we have the federal law, FERPA, and everybody's familiar, anyone who works in a school is familiar with FERPA, and that covers all laws, or all students. And then we have a corresponding state law, 3319.321 there on the slide, which is just has some tiny differences from FERPA, but it's the state law for that, for protecting student records. And then, believe it or not, we have some specific provisions, both in the IDA at the federal level and in the operating standards to the Ohio level, that are particular to special education records. So when we're talking about records for special education kids, you're obviously thinking, okay, I've got these areas that I need to be looking at. What I'm going to be doing is talking about records in general, and where the law gives us something specific about a special education record, I will call that out for your attention. And that is also the way the materials are written. They're general, and then when there is something specific to special ed, it's pointed out in your materials. I will not cover everything in your materials. They are meant to be a reference to you. And I think I may have stolen the SST's thunder by just jumping in. They might have wanted to tell you guys how to find those. If you can't already drop that in there. Oh, there it is. They already did it. Look at that. It's in the comments. They've got the link to the handout in there, which again, I won't cover everything, but I will. It will serve as a great reference. Okay, so let's start with the basics. Next slide, please. There are general prohibitions against disclosure, and that is true of all education records. We are prohibited from disclosing any educational record or the PII. When you see PII on the slides, that's personally identifiable information that is contained therein. So if the information comes from an education record, that is also protected without written consent of the parent or the eligible student. When does a student become eligible? A student becomes eligible at the age of 18. provided that there's not a guardianship or something that's limiting their legal rights. And so generally, that's the rule. We cannot release information or records without the consent of the parent or the student if over the age of 18. So what is exactly disclosure? You can see on the slide, it's permitting access to or actually releasing, transferring, or any other communication of the personally identifiable information contained in the record. And it's, it can be purposeful, it can be inadvertent. So you can have a prohibited disclosure even when you haven't released the record. So let me give you a real life example. When my kids were little, I used to volunteer in their elementary school and assist with things like the bulletin boards or, what's it called when you stick the stuff, laminating things for the teacher and those kinds of things, right? So if I happen to be in a copy room and we're working with either the copier or the lamination machine, and there's a student's IEP that was inadvertently left on the copier, I am in the school. I'm there lawfully, right? I'm volunteering, but I have no legitimate educational interest in knowing what's in that student's IEP. So that leaving it on the copier is an inadvertent disclosure of information. By just glancing at the IEP, someone knows, okay, now I know that that student is a student with a disability. So that's the disclosure of personally identifiable information about a student, and it's inadvertent. So it can happen, by, not intentional means. It's more than just, well, here, let me email you an IEP to someone who has no, that's obviously an affirmative disclosure. But I bring that to your attention because it happens all the time. And so we really do need to be safeguarding the information of our students. Okay, so next slide. What is an education record? So let's talk about, what counts as an education record. So the two elements are over there on the left hand of the screen for you. They are anything that is directly related to the student. So an education record is going to include the student's name. And then this is the biggie, it's maintained by the educational agency or a party acting for the educational agency. And so we maintain records in all sorts of fashions. We may maintain them on a server. We may maintain them in a physical file. But if the district is retaining them, then, and it has a student's name in it, then we are talking about something that is an education record. It includes all forms of the record. So the printout of that, or that record as it exists in its digital form. So again, things that are maintained on a server. It's going to include all of our video recordings, all our hallway surveillance videos, all our bus videos, right? They are going to show a student and they're being maintained by the district. It's going to include our emails when they include a student's name. That is directly going to reference a student and it's being maintained on our server. So it's a wide swath of information. What is not an education record? Your own personal notes. So if you're sitting in a meeting about a student and you're taking your own personal notes and you never use those notes for anything, you don't draw conclusions from them, you don't turn the data into, progress monitoring data. It's just there for your own personal refreshing of your memory. Those are not education records. They're not being maintained by the school district. Employee records. So those are not education records either. Those don't relate to a student. They relate to, a personnel, someone who works for the district. Now there is some crossover. So for example, imagine that you have some records that talk about Maybe there's been an allegation of force or overuse or misuse of force with a student by an employee. You may have a record that is both a personnel record and an education record. You just have to tease that out. But generally, what's in a personnel file is not a student record. Law enforcement records. So those records that are created by the SROs. SROs are typically not employed by the school district. And so those records are maintained by the SRO, and those are police records or law enforcement records. Similarly, that means that an SRO is not a district employee. So we'll talk a little bit about a little bit later about what we do when the SROs come to us and ask for an education record. There was a case many, many years ago from the US Supreme Court that talked about, well, what if teachers do pop quizzes and then they say to students, exchange the quizzes and grade each other's quizzes. Is that the disclosure of personally identifiable information about a student to someone else? And there's a whole Supreme Court case on this that the grades on peer graded papers before they're actually collected is an exception. It's not an education record. So if the students are asked to call out the grades and then they're recorded in a grade book, well, okay, then maybe. But the grading before that happens, the graded document is not a disclosure, not an education record. Treatment records, we may have certain treatment records in our possession. Most likely we do not. The definition of treatment is a term of art. In many cases, we are not treating, but to the extent that we do have treatment records, psychotherapy notes, again, many of us are not running, let's say, substance abuse treatment programs, those kinds of things. Those are not education records. And then anything that's covered that you've exchanged with a lawyer. So attorney-client privileged information is not an education record. So if you've exchanged an email with a lawyer about a student, that is directly related to a student, but it is privileged. And so it does not go into, that communication does not go into the student's education records. So there are some exceptions, and sometimes it's easier to look at the exceptions to figure out what is an education record than to actually, try to fathom the whole world of what's directly related but to a student and maintained by a district, because it's a very broad definition. Okay, next slide. So let's talk about surveillance videos, because this is something that gets a lot. I probably address this question a half dozen times a year. There's a fight, there's a bus video, parents say, I want to see the video, and schools say, we don't share video. We don't allow you to access videos. That is, there was, before 2017, some conflicting guidance out of the US Department of Education. But since 2017, we have a letter, it's called the Letter to Watcher. And they made it very clear that videos are, or can, I should say, be education records when they directly relate to the student about, let's say, discipline. So if you have a bus video, you might have two kids, let's go with two in my hypothetical, that are in a fight. That fight that is recorded that involves the two students who may be facing discipline, that video is an education record for those two students. It's about them. The district is going to use it for the purposes of discipline. So it's directly related to a student and student discipline, and it's being maintained on our servers, right? So it is an education record. That means that parents have the right to access that. What about everyone else on the video? What about all the other kids in the seats? Well, the US Department of Education said they're just window dressing. It's not really an education record for those students. So, they said if school districts have the ability to gray out everyone else, well, then certainly do that before you provide a parent access to that video. But if you don't, that's okay too. The parents still of the disciplined students still would have the ability to access that video. So you'll see the last bullet point, parents and eligible students have a right to view them. Um, and so that is kind of the rule on video. And so like I said, I very frequently end up addressing that issue. That's also true of, let's say, witness statements. So let's say that a principal has taken witness statements from everyone on the bus about what happened, and those witness statements have multiple names in them. Well, again, to the extent that it references one of the discipline's students, it is an education record for that student-facing discipline. Is it an education record for the witness? I mean, to the extent that it tells us that that person was a witness, yes. What we often do is provide, if we can, we recommend providing the witness statement in a highly redacted form, so that maybe the witness name and other witnesses referenced in the witness statement are redacted, but the student disciplined is unredacted to the parent, right? And so usually there is a way to continue to disclose those or provide access to those. But I put a slide in here about this because this is one of those areas that we get a lot of, and we spend a lot of time helping districts, segment out what is and isn't disclosable in those surveillance videos and witness statements. So notice that on the last bullet point, you'll see the right to view is in green. We tend to try to put terms that have nuances to them or that are of particular interest that we're going to emphasize in a different color. And the reason that's there is because you do not have to disclose the video. In other words, what we often recommend with videos is that you bring the parents in or the students and let them view the video. FERPA provides access to the record. It does not entitle them to a copy of the record. And as we all know, what frequently happens with videos is they go straight to social media. And because we don't want to be responsible for additional disclosure of personally identifiable information, we will not provide them copies of the video, but we will give them access to the video by bringing them in and allowing them to view it. Okay. We sometimes get the question about testing protocols, and they are records. There are some fine line distinctions here. They are records if they have the student's name on them, if they have personally identifiable information on them. So sometimes the protocol has just the questions, and there's an answer sheet that has the student's name on it. That would be then the question booklet is protected by copyright. We're not going to disclose that, but the answer sheet may in fact be something that we would have to disclose or provide access to if it has the student's name on it. I've had districts ask me, trying to be very cute, well, what if we don't have the district's name, the student's name on it? Well, I don't think it's a very useful document if you ever need to go back and rely on it, because how do you prove that belongs to the student? I don't think there's any reason to be terribly cutesy about that, but I do think that there is a good practice to separate, let's say, answer keys from testing booklets, because again, testing booklets have all those copyrighted information, whereas the answer key does not. And so again, this is one of those areas where I think being thoughtful about the way that the record is maintained can help manage the disclosure of those. You'll note that the parent does have a right to receive explanations or interpretations of education records, and that's not just true of testing protocols. And so, you may, as you are providing, let's say, an answer sheet, be providing access to someone who can help them, decipher that. The other way that testing protocols are often addressed in the disclosure realm is that many times psychologists and psychiatrists have, through their own licensure, certain codes of conduct that they have to adhere to. And we have worked out agreements where we will disclose the information professional to professional. So a psychologist may make a testing protocol or an answer sheet available directly to, let's say, an IEE evaluator, psychologist or psychiatrist, rather than disclosing that out into the public, to the parent to be conveyed. And so there are ways to work around those copyright laws, or to work within, I shouldn't say, I'm not trying to get around them, and still, give parents the right to the access to access the information and have their professionals access the information. Okay, so what is personally identifiable information? What is PII? So I always say that whenever we get a list from the federal government about what is something, it's not exhaustive. But this is a pretty good containment of what is personally identifiable information. Of course, the student's name, their parents and other family members, their address, their social security numbers, their student ID numbers, their biometric records. So to the extent that we are using, I know some districts are using like a thumbprint for kids to log in for their lunch accounts, right? And so it's scanning a thumbprint. We know that some districts have, not many, but we know that retina scans are a means of security. And so those would be the type of biometric records that you might be maintaining that would also be personally identifiable information. Then we have what we call the connect the dot definition of personally identifiable information. So it's other information that a reasonable person in the community would know or be able to identify the student with reasonable certainty. So let's say that there was a fight and there was a very public arrest, and I don't know, your local newspaper has the student, a picture of the student being carted off in handcuffs. So everyone in the community knows who was in fact involved in the fight. And now there's a request for documentation, public records request for documentation for all disciplinary or record information about fights, right, on a particular day. Well, if you release it, even if it's in its redacted form, right, if you released a redacted record, everyone in the community knows exactly who that's about, because there was enough information floating out in the community to know, yeah, I know who that record is about, even in its redacted form. So we call that the connect the dot exception. If someone in the community can connect the dots, and that often happens when somebody who is not related to the student knows that something is occurring and they ask for something specific to that student as a public record. Again, we end up spending time figuring out, if we redact this, even if we redact this, can the person figure it out? And if so, then it is still the disclosure of personally identifiable information, which you could not do. So that one is lesser known, but often used provision to hold back on public record requests. So any questions so far? I'm going to peek. I see my little red, nope, those are communications from the SST. Okay. So let's talk about when we can disclose. So far I've talked about, what is a record and this prohibition on disclosure. So like any legal rule in the world, there are exceptions to the rule. And sometimes I think that the exceptions for FERPA and student records sometimes swallow the rule because there's a lot of them. And I'm not going to talk about all of them, but let's talk about some of the most common ones. So who can access records? As we said, the parents can access records, right? And notice I'm not saying release, it's access. And so you may have a board policy that says you're going to release them, you're going to release copies, but you could also, in some cases, decide that you are going to respond to a parent's request for education records by putting those records in a room and saying, yeah, they're here, come thumb through them, right? That is access. That is compliance with the law. Eligible students, we talked about that. That's the students that are over 18. And then school officials with a legitimate educational interest. Actually, as I'm looking at my materials, in addition to the slide, let me give you a couple of exceptions to parents. Parents include biological parents, even non-custodial parents, unless the only reason parents can't access education records is if there's a court order changing their rights. So if a parent has had their rights terminated, then obviously we would not be disclosing that. The other thing about parents is there is a special exception for victims of domestic violence. If a parent were to come to you and tell you that they have a protective order, there is a specific, against the other parent, there is a specific exception there as well. So there are a couple of exceptions there in your materials on parents. When we talk about eligible students, the rights to access the records transfer to the student at the age of 18. But there are some special exceptions to when we would continue to release records to parents after that right transfers to students. The most common one is that when the eligible student is still claimed on the parent's tax return. And that is usually most of our K through 12 kids still. You do not have to ask to see a tax return. You are allowed to rely on the parent saying, yeah, I still claim this kid as on my tax return. They're 18, but I can access their records. However, for those of you out there who have college age students, think about that when they go off to college and you're paying tuition and the right to their records has transferred to them. So conversation for them, you may need consent from the student. And many colleges and universities require the student to consent to the disclosure of records to parents. So keep that in mind. There are some special rules about kids once they turn 18. Again, if there is a guardianship, the student's been declared incompetent, and that does happen with our students for disabilities, then there may be an exception there as well. One other one, and this is specific to special education kids, there is a rule in the operating standards that specifically says that even though the rights to records transfer to eligible students under the IDEA and under FERPA, right, that when you provide procedural safeguards to a student over the age of 18, that document should go to parents and the eligible student. And so there are certain records that, like while the grade card may not, that the procedural safeguards under the IDEA go to both. It's kind of a paternalistic protection that exists under the IDEA. So let's say that you have a special education student that's saying, denying their services. I'm going to exit. I'm 18. I no longer want special education related services. They've not been declared incompetent. They're going to exit themselves. That prior written notice about exiting them would go to the eligible student and to the parent because of a special rule under the IDEA and operating standards. And that is referenced in your materials as well in a footnote, so you can see that under eligible students. Okay, now I blew through those first two without any exceptions. Let's talk about school officials with a legitimate educational interest. So I do, but before I do, I see a question. I have a question that is, what if the student has said they do not want their parent involved? if they are a special education student and we are under that IDEA rule, you need to explain to that student that this is a federal law that you must comply with and that you must disclose that prior written notice to the parents. In this day and age, I don't know that I'm going to ever counsel a client to not follow or comply with parental rights. They're enjoying a huge resurgence. And so that's a federal right that they have. So I think you just have to tell the student that you have this obligation to disclose under federal law. Good question, though. All right, school officials. So school officials with a legitimate educational interest. You do not need consent to have a conversation with a colleague about programming for a student. So if you want to, brainstorm with other ISs about how you might, address a student's need with certain interventions, those are people with whom you're having a legitimate educational conversation. And so you don't need consent to have to disclose personally identifiable information there. Definition of who is a school official is contained in board policy. It's usually those people under contract. So in addition to those people that are working for the district, you might have, let's say, ESC, related services professionals that may have a legitimate educational interest in having some information about a child in order to program for them. School attorneys are often included in that, again, so that you can have discussions about programming and staffing and those kinds of things. And then other individuals with consent or qualifying exceptions. And so we have those three biggies: parents, eligible students, and school officials. And then I always say you can do anything with consent. And so we're going to talk about some of those issues that are coming up with the qualifying exceptions. Okay, so when you do get notice for consent, I'm turning on my space heater. That's why I'm looking down here, because this room that I'm in is freezing. Just a second. Okay. So when you do get a release, some of the things that you are looking for is that that release, so if someone's giving you consent, says what is going to be released, right? It may say all education records. That is legit. But it may say, I only want the education records, or I only want the disciplinary records, right? And it may state the disclosure, the reason for the disclosure. So, the attorney can help me, I want you to disclose these records to my attorney so they can help me in educational programming. And they are frequently dated. They do not have to be dated. But they may say this, is good for a year. So things to just be looking at when you've got a record release. Okay. So what about the qualifying exceptions? And that's the slide here. Thank you, Maya. So there are lots of areas where the qualifying exceptions come into play. What can be released? You can release directory information. And so you do not need consent to, usually that is designated by the school in an annual FERPA notice. It's usually things like name, grade, member on athletic teams. This is how you release information to, the local paper about how your football team is doing. Those things that are defined as directory information. There is in your materials a definition, but a district can change those. As I said in the annual notice, but you'll see it says student's name, address, telephone number, date, place of birth, enrollment dates, participation in school activities. So again, the athletics, key club, honor society, and then the height and weight of members of athletic teams. Never seen that actually disclosed, but that is defined in the federal law as well. Directory information does not include the student's ID number. It doesn't include the student's social security number. And again, that can be modified by the district. So districts have, for example, removed address from directory information because they will get a public records request for people that they know, community schools or private schools that want to solicit families for using the scholarships, right? And they're not going to help people, siphon money off of public schools. And so they take the address out of directory information. They don't have to disclose that when asked. And so, again, districts can modify that. All right, health or safety emergency is also an exception. So schools can disclose personally identifiable information to appropriate parties in connection with a health or safety emergency. This was added to FERPA after the Virginia Tech shootings. I don't know how many of you were in education at that time. That was 2010. I know that because the Virginia Tech shootings were the headline on the day my son was born. But one of the things that Virginia Tech struggled with was disclosing information to the police about the student. There was information about the student and some mental health issues that had existed and that the college and university was aware of, and they couldn't disclose it. And so that is a specific exception that was placed into the law after that. If what you need to have in order to use this exception is a significant and articulable threat. So it can't just be, I have a hunch, right? You've got some sort of information that makes you think that there is, in fact, a health or safety emergency and it's imminent, and you can articulate, what it specifically is. There is a totality of the circumstances requirement here too, that you're looking at everything. This is one of those where if you are truly in an emergency, I'm not going to, split hairs with you. Let's go ahead and disclose the information to law enforcement that we may need to do so. Okay, if you do that though, you are required to log that in the student's records. So I did make a disclosure because of a health or safety emergency. And so that is a special rule on that health or safety emergency. You may disclose information to the student's new school. And so records can be disclosed to officials where the student seeks to enroll or has enrolled. And so we get obviously those requests for records from other schools where they're indicating that the student has enrolled. Now, there are specific rules here as well under the operating standards for students with disabilities. So the previous school district must send the IEP and a statement of current or previous disciplinary action that has been taken against the child. And that's a specific rule under the operating standards. So we are going to disclose, we've had a manifestation determination and the student it was found not to be a manifestation and the student is currently expelled, right? That information is also going to go to the student's new school, and that's specific to students with disabilities. There also has to be a statement regarding that disciplinary action. This is in your materials. That includes information relevant to the safety of the child and others, and whether or not we took the disciplinary action because of any of the safety exceptions, weapons, drugs, or serious bodily injury. There is a requirement or a provision in the law that says the statement regarding disciplinary action may include a description of other behavior engaged in that required that disciplinary action. So, you may be in a situation where if this has been, leading up to or was the culmination of a pattern of behavior, you can disclose that kind of information as well. There is a timeliness requirement under the operating standards. The IDEA states that where a special education student transfers to another district, you must promptly respond to those requests for records. And that is pretty much covers all of the students' new school. There is one Particular provision I want to bring to your attention also in your materials for private schools. So when the student's new school is a private school, the IDEA requires that if the child's going to enroll in a private school, outside of the boundaries of the parent's school district of residence, okay, so they're going to a private school that is not in your geographic boundaries, then there's an exception to the exception, and that is then you need consent to disclose those. Again, that's in your materials under disclosure to the student's new school. It's the last provision that addresses that private school exception. Okay, where else is there an exception? Government officials. So we will often get questions from ODU or OCR or the Department of Education asking for information about, let's say, bullying reports or those kinds of things. So there's audits or collection of information for government officials. We can disclose personally identifiable information there. We often do it when we're in the middle of an investigation as well. We don't need consent when we are releasing records to ODU in a complaint or to OCR in a complaint. And so that is a specific exception. Armed forces recruiters is individuals who can access personally identifiable information. That's written directly into the law. And also that is very frequently addressed in the annual FERPA notice that students or that districts put out, that we will be disclosing to those. Now, parents can opt out of that. And if parents say, I don't want my information released to armed forces recruiters, they can do that, but they need to be advised that it's not, that when they opt out of that disclosure, they also opt out of all similar disclosures. So for example, for college recruiting or, you may have local colleges and universities that are asking school districts for the names of juniors and seniors so that they can start sending them information. They opt out of all. It's an all or nothing piece on that. I see a question popping up. And it's not coming all the way through. Okay. A question about surrogates. If a student lives with a parent, but we cannot reach them for consent paperwork after trying a number of methods, do you recommend doing the consent override via a PRO1 to get a surrogate to be safe? Well, you know what? We're doing procedural safeguards in the second hour, so I'm going to kick that one to the second hour because I do talk about surrogates. The rule on surrogates is pretty clear on when you can get a surrogate, but we'll go over that. All right, let's go back to qualifying exceptions on the rules on records, disclosure of records. We can disclose de-identified records. So, for example, remember when I was talking about witness statements in a student fight, and we might be able to disclose that witness statement with certain information redacted. But remember, in de-identified records, that connect the dot exception. So you need to look at the record and think, do other people in the community have enough information that even if I take this name out, they're going to know who is referenced in this record? And so that is a special exception that requires a little bit of extra thought. Courts and subpoenas, they can access records. So anytime I have a client that calls me and says, I have a court order, I'm like, yep, we're disclosing it. I have never, ever advised a client to defy a court order. That's a nice way to end up in contempt of court and get jailed. Courts can access what they want to access. Now, there are some specific rules. Sometimes a court order will say, well, let's talk about subpoenas first. Subpoenas are a form of court order. They usually exist. There has to be a pending case, and a lawyer issues that and requests certain records, and it is filed with the court or signed by the judge as well. Sometimes it's just filed with the court. we will release pursuant to a validly issued subpoena as well. But there are some special exceptions, and that is not special exceptions. There's some special steps that have to be taken. With a subpoena, the law requires that if you receive a subpoena for records, that you notify the parent or the eligible student, I've received a subpoena for your records. I'm going to have to disclose your records on, Friday, January, 19th or whatever. If I do not receive something that tells me you've gone into court and asked the court to modify this order. So what you have to do is give the owner of the record an opportunity to march into court and quash the subpoena, which means tell the court it's overbroad. So let them go duke it out in front of the court. But you have to give them notice, and you have to give them enough time to do that, right? So you can't give them notice on the day before you're going to comply. And so there's a special rule there. There is one exception to that, and that is certain grand jury and criminal subpoenas will have special language that says that the party is prohibited from giving notice of the subpoena to the owner of the records. Those don't exist very often, but if you do get one in a criminal context, again, usually grand jury subpoenas or criminal, felonies, those kinds of things, that language can exist in those, and that would be the exception to having to give them notice, because they can't go quash a grand jury subpoena. But a civil subpoena, let's say in a divorce action, you may have the other parties duking that out. The district is going to remain neutral. You're just saying, I'm going to produce them unless you go tell me you've got an order that quashes this subpoena. So that is an exception to when we may disclose without consent. Okay, and there are certain discipline and behavior records that we might be able to disclose in certain situations where there is a legitimate educational interest. And this frequently comes up in Title IX, but there are also some safety and well-being exceptions there. If you're looking at those, I'd encourage you to work with legal counsel on those. So when I said that there were often exceptions that swallowed the rule, this slide is what I meant, right? There are lots of ways that there are exceptions to the prohibition of disclosure of records, that we may run into here. Okay, let's talk about redisclosure restrictions. So what happens when you disclose the information? Is your obligation done? And the answer is there is a provision in both federal and Ohio law that districts can disclose, or can only disclose, the personally identifiable information from education records on the condition that they tell the recipient, hey, you're not supposed to disclose this either. So let's say you release the information pursuant to a release of records that the parent has signed to school, their private psychologist, right? Those should be accompanied by a statement that says this is being released to you on the condition that you will not disclose the information to another party. Do you have to police that? No, but you do have to give them notice. And so that is a requirement on the that we give that, you're prohibited from redisclosing this information. Okay. We've already talked about all of that. So next slide, please. A little known provision of FERPA is that you are supposed to be keeping access logs. So districts are required to maintain records of each request for access and disclosure of personally identifiable information of the students. And now, if we were in person, I would be looking out in the room, and you all would have like looks of panic, because you're going to say, I've never ever logged when I've disclosed information because of a legitimate educational interest, or pursuant to all of these releases, right? Well, That's because, again, there are exceptions to the rule. And they are listed in your materials. The access log does not have to log disclosures that are made to parents, to students. So students come in and look at their records, parents don't need to log that. School officials with a legitimate educational interest, they do not have to do it with written consent. They do not have to do it when somebody's seeking directory information, or when they are in connection with certain law enforcement proceedings, if the court agency orders that it remain confidential. And that's that language I was just talking about under the grand jury or criminal subpoena, right? If that order says that it's supposed, that the fact that you're making this disclosure is not to be released to the parent, then again, that's the exception. And so you can see there's a lot of reasons we don't have to write it in the log. But this access log does exist. And so we're supposed to be keeping an access log. We are required to list what employees have access to education, personally identifiable information. And that list is a public record. So usually a treasurer has a list in the district that says, employees with legitimate educational interest can access this, along with, director of special education and curriculum directors and those kinds of things, right? So that is usually maintained by your official records custodian, which is typically your treasurer. The IDEA does require that each district have one official designated as responsible for ensuring the confidentiality. Again, that's usually done in board policy, and it's usually the treasurer. They are designated the records custodian. And anyone who's collecting personally identifiable information must receive training on the confidentiality requirements, which is why you almost always have in public school works or those kinds of things, your annual FERPA training, right? It doesn't say that it has to be annual, but you do need to have the training, and this would count, right? So what are the rights of parents in addition to being able to access the records? There are certain rights that are defined both under federal and state law for parents. Districts must annually notify parents of their rights. And I've referenced it a couple of times. There's an annual notice, right, that we put out. And it's, in those documents that go out at the beginning of every school year that, parents do, and your annual FERPA notice is in there. And parents, check off, yeah, I received it. But what does it have to tell the parents? It has to tell them, number one, that they control the ability to, access to their students' personally identifiable information. And then it has to also tell them, hey, there's a procedure for how you inspect or request those records. There's also a procedure for how you might amend those records. So you might get a request to change a record, and there's a procedure for that. It will tell you who is a school official. Remember, I told you that annual notice had that. It's going to tell parents, so teachers and, administrators and people that are under contract with us serving your student, may have a legitimate educational interest. So it's going to give them notice of those people. And it's going to give that definition of directory information. So this is the information that we're designating as directory information, and we can disclose this without your consent. So your student's name, address, whatever, right? And then it gives them the ability to opt out of that disclosure. So let's say that's where they would say, I don't want recruiters to have that information. That's, military recruiters and college recruiters, right? So there's this annual notice requirement. There is also in this rights, this notice, this idea that, again, that they can consent and to the disclosure of records, and that they have a right to file a complaint with the Family Policy Compliance Office. So people often ask, how is FERPA enforced? You file a complaint with the Family Policy Compliance Office. I'm having difficulty because in my world, we just call it FPCO. So I think the next slide, before I leave this, I think the next slide addresses what yeah, inspection of records. Okay, so you have the right as a parent to control the disclosure of records. You have a right to receive that notice and then do the opt-out. You also have the right to inspect the records or have a representative inspect them or have access to them. And this is how the parent gives access, let's say, to their lawyer for education records. What's the timing for that? It's without any unnecessary delay. Okay, so let's go backwards here. Let's go down to the indented bullet point. FERPA says you have 45 days to comply with a record request, up to 45 days. However, districts have been dinged on this reasonable period of time because, for example, if a parent asks for education records and you routinely respond to those within 3 days or a week, and then you know, with a different parent, you're like, well, I'm going to take 45 days because FERPA says I can have 45 days. You set yourself up for discrimination or retaliation, right? This parent's a pain, I'm retaliating against them, right? So I very frequently will recommend the clients not use the full 45 days. When I get a really large record request, often what we'll do is we'll produce what's easy to produce quickly. And then maybe we're going to have to go through, you know, let's say correspondence and do redactions. And I may tell the requester, hey, you know, here's the CUME record and the special ed records, and we're working on correspondence and we'll produce that soon, right? So you partially complied, and that may take us 45 days to get all the way through that, but I wouldn't hold the whole request. Okay, so that's a general rule. But I told you I would be pointing out to you when the rule is specifically different for students with disabilities. And when we have a special rule in the operating standards that says the right to inspect requested records should happen without unnecessary delay and before any IEP meeting, due process, or resolution session. So I have on occasion gotten a record, you know, we've scheduled an IEP, the annual IEP, and 4 days before the IEP meeting, we get an education record request. And the language under the operating standard says I can't hold that IEP meeting until those records have been produced for inspection. And so we may need to reschedule. We may need to scramble to, if we can't reschedule, we may need to scramble to get those records produced before the IEP meeting. And so that's a special rule there. And so with special education kids, the first question I usually ask is, do we have a meeting scheduled when we get a record request, right? Because that's my deadline. It's not the 45 days, it's before the meeting. And so that's that special rule I wanted to bring to your attention. Again, to the extent that an education record has other students' personally identifiable information, so that witness statement, let's say, in a fight, right? Though that personally identifiable information would need to be redacted. Now, if I redact that information and the requester would still be able to connect the dots, then I haven't redacted enough information, or I need to be consulting with counsel on can I actually release that record because of the connect the dot exception. So keep that in mind when you're working on responding to the records request. Next slide, please. Okay. The IDEA also allows, I've never actually had this, parents to request a list of the type of records and the location of records. I've actually never had a parent do that. You have to comply with reasonable requests for explanations and interpretations. That's that idea of you may produce an answer key, but ultimately you may need to sit down, an answer key to a protocol or testing protocol. You may need to provide explanation to the parent or their requester for what that looks like. And that's again often how we work from psychologist to psychologist on the release of that kind of information. Districts are not required to provide copies. As I've been using the term all morning, this is about access, right? And so, you do not have to make copies of absolutely everything, unless not doing so would effectively prevent the eligible parent or student from exercising their right to review them. For example, I may be able to put the CUME file and the special education file in a conference room and say, here's your access. This room is available to you from 8 to 4 on these 4 days. Let me know when you'd like to come in. That's access, right? But if the non-custodial parent lives in Kansas, they cannot do that, right? They are not going to be able to, take a flight and come over and access the records. And then we would be providing copies. So that is the rule on access. All right, next slide. All right, so I kind of wish we were together because this is one of my favorite questions I love to ask. One of the questions I ask is, how many of you have ever written a prior written notice you're really proud of, and then the parent writes you and says, I want you to amend that prior written notice? Never happens, right? Okay, well, so what do? Parents do have the right to ask you to amend a record, but it's only when they believe that the record is inaccurate, misleading, or in violation of the student's privacy. So 3 things. Is the prior written notice inaccurate? Is it misleading? Or is it in violation of the student's privacy rights? If they don't like it because they don't like what it says, right? They disagree with the ultimate determination. That's not inaccurate. That's I disagree, right? It's also not misleading unless your prior written notice doesn't note that they disagree, nor does it violate the student's privacy, all right? So those are the reasons that a parent can ask to amend a record. The district, upon a request, has to decide, am I going to comply? So the first thing I always do is say, is it inaccurate? Is it misleading? Is it a violation of the student's privacy? And if the answer to those are no, then, we would say, no, we're not going to amend. That often does not end the matter, right? But that's the threshold question is, is it one of those 3 things? Okay, so after that, then what can happen? So if the parent still disagrees, they can ask the district for a hearing to amend the record. And the district has to, and this is all in board policy as well, the district has to appoint a hearing officer. That parent comes in and presents their case on why the record's inaccurate, misleading, or in violation of the student's privacy rights. And the district, presents evidence on why, no, it's accurate, it's not misleading, and it's not a violation of the student's privacy, right? If it's inaccurate, we would correct it, right? We've missed that someone's there. We have a date wrong. We said we would do something when we meant to put we would not do something, right? Those are we're gonna fix those, but all these others, right? No, we wouldn't, right? It's accurate. So then the hearing officer makes a decision, and we either win or lose on that, and we either amend the record or we don't. At the end of that process, the hearing process, the parent is still permitted to write a statement of disagreement that would be attached to the record and maintained with the record for all time, right? So ultimately, that is the upshot of going through the amendment process. So frequently what we see happen is that districts will say to a parent who is asking for that prior written notice to be amended, we will say to them, no, we believe it's accurate, not misleading, and not a violation of the student's privacy. Here's our board policy on how you can request a hearing to amend the record, or if you would prefer, we are happy to take your statement of disagreement and attach it to the record. And you can sometimes shortcut that hearing, right? They can choose to go to hearing, or they can choose to do what they would get at the end of the hearing anyway, which is the right to attach their statement of disagreement to the record. And so that is typically the way we recommend you address the amendment of record request from a parent. And that statement of disagreement, if it's attached, must be maintained with the record. And every time that record is disclosed, that statement of disagreement goes with it. That's what you're telling the parent you will do. So, all right. Next slide, please. Okay. So what about retaining and destroying education records? So destruction is defined in the operating standards as the physical destruction or removal of personal identifiers from information, so the information is no longer personally identifiable. It's pretty easy, right? So we may be either redacting or we may be destroying the information. We are doing this, if we're not maintaining them any longer, we are doing this pursuant to our record retention schedule. So every school treasurer is aware that there is a required record retention schedule. It tells districts how long they keep records, anything from personnel records to collective bargaining agreements to student records. And there are lines in this schedule for how long we do that. Usually for things like evaluation information and special education records, they're permanent, but there are some I've seen where they might have a 15-year, retention, 10-year. But in any event, we can destroy that, but we must do it in accordance with that procedure. And we must inform parents of special education students. So this is specific to special education students when that information is no longer needed. And this is why this provision is often why you see special education records permanently maintained, because going through and doing that in informing can be a pretty big undertaking. Okay. Records that cannot be destroyed. This is addressed in your materials. Districts cannot destroy records while a parent's or eligible student's request is currently outstanding. That's a crime. So we're not going to do that. And you want to make sure that we are still maintaining permanent records as required. So these pieces are addressed in your materials as well. Okay, so let's say we've done something wrong. FERPA has been violated. What is the upshot? How is FERPA and these laws, how are they enforced? Well, the first, I think I have a slide on enforcement. The first way is ODU enforces violations of the confidentiality provisions of the IDEA. So a parent can file a complaint with ODU and say, hey, the confidentiality provisions of the Ohio operating standards and the IDEA have been violated. Some information was disclosed to a transition provider or a third party that I never consented to because there was no way I was going to ever enroll my kid there, right? So we do end up defending these in front of ODU. And then there's also the SP, that's actually should be SPCO. It's not policy office, it's actually compliance office. That's the one I was telling you about earlier. The Department of Education has the Student Privacy Compliance Office, which will also investigate complaints of FERPA. And then in Ohio, you can also file an action in Ohio law under the corresponding Ohio statute, which is 3319.131, I believe. And so that's not listed on the slide, but you can file an action in state law for these as well. What is the upshot? Well, the good news is that there is no private cause of action under FERPA, which means that there is no, there aren't punitive damages, there aren't monetary damages. So for the teacher who left the IEP on the copier while I, parent volunteer, was in there, working the copier or the lamination machine, that person would not face monetary damages, right? The district might face a violation on you didn't maintain the security of confidential records and might in a complaint be forced to do training, but there are not monetary damages to confidentiality breaches. There has recently been an exception to this. I noted it's probably been in the last 6 months that where there was an egregious disclosure, a educator lost their cool and went out onto social media and blasted personally identifiable information in anger. That was held to be a civil rights violation, violation of the student's right to privacy and humiliation and bullying. And so they used that to go after monetary damages in a more egregious fashion under other laws. But under FERPA itself, there's not a private cause of action. And so that's the good news. The other good news is that a private cause or a complaint with the Federal Policy Compliance Office, SPCO, would be needs to be brought within 180 days. So they are time limited. So with that, I believe that I have addressed all of the records and confidentiality things that I was going to. So that was topic 1 for us. And it's on 10:12. I'm going to ask if there are any questions. And if not, I think this is a good time to refill our coffee cups before I dive into procedural safeguards. And I will begin with surrogate parents to our questioner who had the question earlier. But why don't we take, why don't we come back? I have 10:13. Why don't we come back at 10:23? And I will finish up in the last hour with procedural safeguards with you. Does that sound good? SST, Maya? I
Yes,
got it.
that 10 minutes is good. Thank you.
All right, great. Thanks. See you guys soon. I'm back. Over the break, I got a question about the length of time districts are required to keep evaluation protocols used for special education assessments. That would be specific to what is contained in a district's record retention schedule. And so that is a question for your district treasurer, who is probably the records custodian, and what is in your record retention schedule, which is called an RC-2. And they'll know what that is. So that particular question is not controlled by law. And then with that, I'm gonna dive into procedural safeguards. But I wanted to, well, let's talk about surrogate parents and then I'll address the question that was raised. The first procedural safeguard that I'm going to talk about, and so all procedural safeguards come from 3301-51-05. Just did that from memory, which is the provision of the operating standards that covers procedural safeguards. It's the longest of the rules. And so we're going to hit the highlights, the first one being surrogate parents. So when do you have to appoint a surrogate parent? You must appoint a surrogate parent to ensure the rights of the child are protected when no parent can be identified. So we don't know who the parent is, right? The district, that's very frequently going to happen with an unaccompanied youth. Runaway that presents, right? Those kinds of individuals. The district, after reasonable efforts, cannot locate the parent. So a parent goes MIA. The child is a ward of the state under Ohio law. So they're in foster care, and there may be a situation where you would be appointing a surrogate parent. You'd want to know what if there's a court order that has already appointed someone to act as the educational decision maker / parent, or the child's an unaccompanied homeless youth. And so these are the reasons you would need to do a surrogate parent. And the surrogate parent then has all the rights of the actual biological parent. And the entity that does that is the district of residence, although that can be delegated. And it is very frequently in situations, let's say, where a student is in the custody of the state of Ohio. You are the DOR, and the JFS or Children's Services has, let's say, placed the child outside of your geographic boundaries. Maybe you're a Columbus district and they've put them at Monarch in Cleveland, right? You may ask the school district of service where the child is attending in those distance cases to go ahead and appoint the surrogate on your behalf. So there is one, small delegable kind of situation, but generally it's the district of residence that assigns the surrogate parent. Okay, so the question that we got before the break was, okay, what if you have the student lives with the parent, but you can't reach the parent? So the parent can be identified in that situation. Because we know they're living with the parent. And after reasonable efforts, you can locate the parent because, again, the student lives with them, right? So I don't think you are at a surrogate parent situation there. The question was, do you recommend doing the consent overrides or getting a surrogate parent? You can try the consent override depending on what you're looking for, whether you're going for, evaluation or something like that. But remember, there are certain things that you cannot override parental consent for example, change of placement. So you cannot do a consent override because you can't find the parent on change of placement. But I don't think that if the student is living with the parent, that you are in a situation where no parent can be identified. You just have one that is not being very cooperative. So there you go. There's my answer on that. And of course, I would answer that in the hypothetical and tell my poster to consult legal counsel on that too. So, all right. Next slide. So surrogate parents have to be trained individuals who act in the place of parents to make educational decisions on behalf of a child. And so essentially they are going to act as the parent for all matters related to identification, evaluation, placement, and the provision of FAPE. Our federal and state regulations give us certain criteria for the selection of a surrogate parent. They can't be an employee of the state. They can't have any personal or professional interest that conflicts. They have to have knowledge adequate to represent the child. So they have to have gone through SST training for that. And so there are certain criteria for that. But again, when the child has a surrogate, that surrogate is going to represent the child in all matters. They can review records, they can provide consent, they can agree or disagree with certain decisions and exercise all of those dispute resolution mechanisms. So they're they act as the parent. Okay, do I have a question on consent? We're going to talk about consent in a minute. So and then do I need a surrogate for kinship place students, meaning that they're acting there by kinship? Okay, so I assume you mean a family member. It would depend on the question of who that person is. If you look at the definition of parent under the operating standards, it begins with a definition of biological parent. And then one of the next definitions of parent is a family member with whom the child lives, like a grandparent, sister, blah, 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 blah. If that kinship fits in that exception, and I don't have the operating standards in front of me, then no, that person could act as the parent. But what you need to do is look at the definition of parent in 3301-51-01 and see if that kinship fits the definition of a parent. Okay, next question. Well, you guys are all over the surrogate parent thing. Surrogate parent for all students or wards of the state, or only for those for whom parental rights have been otherwise removed? No. Can we go back, Maya, to the definition of when we do a surrogate parent? No, that is the full, no, there you go. Third indented bullet point there, child is a ward of the state under Ohio law. It has no distinction on whether or not rights have been terminated. And so very frequently we do have surrogate parents appointed in situations where the parents still have residual rights. The definition of parent in the operating standards gives you a hierarchy. So let's say you have a surrogate parent and a biological parent at the table, and you're trying to figure out, well, okay, you made me appoint the surrogate parent because they're a ward of the state, you know, who gets the rights, right? Unless the parents' rights have been terminated, they win that one. And so the language that I'm looking at, since we're getting so many questions on this, I'm looking at the definition of parent because I believe that's where it is in the operating standards. Yeah, so the definition of parent includes a biological or adoptive parent, a guardian, so this goes to the kinship, generally authorized to act as the child's parent or authorized to make educational decisions for the child, but not the state. Actually, that's a guardian. This was the kinship one. An individual acting in the place of a biological or adoptive parent, including a grandparent, step-parent, or other relative. So that might be your kinship person with whom the child lives. A surrogate parent. So all these people meet the definition of parent. Then the law goes on to say that when you have more than one person attempting to act as parent under the rule, the biological or adoptive parent must be presumed to be the parent for the purposes of this chapter. And so they win. They get the trump card, right? So we've now left the procedural safeguards rule and we are in the definitional rule. So I'm going to get us back on track, but those are all good questions. Okay. Next, parental consent. We were just talking about parental consent. So let's talk about parental consent. You need informed parental consent for certain things under the IDEA. And this is a procedural safeguard. The first one is for initial evaluation. So a district proposing to conduct an initial evaluation must get parental consent before the initial evaluation. We don't go around assessing kids until we have parental consent. You also need it for the initial provision of special education and related services. Notice it does not say you need consent at the end of the ETR, right? Parent doesn't have to consent to what we decide in the ETR. It does not there, right? We've moved on in the process, but they do have to consent to the provision of special education and related services. They also, for reevaluation, we would need consent, and before a change in placement. So these are the 4 areas in which you need parental consent. So let's talk about when you can do the override. So you can do an override on for services. You can do an override for parental consent for services. And there are some special rules for reevaluations. If you can demonstrate that you made reasonable efforts to obtain such consent and the parent did not respond. So parental consent need not be obtained if the district can demonstrate that it made reasonable efforts to obtain such consent and the parent did not respond. So that's for re-evaluations. You could also do a record request. And then we have the big one on before a change in placement. We can also override, we need to go back, but you are not required to override the lack of parental consent for the initial evaluation of a child. I don't know many districts that would use that override, because if you're overriding on initial evaluation, yeah, you've gained some great knowledge about the student and you might educate the parent in the process, but there's a pretty good chance you're not going to get consent for services. And so that is not something you frequently see. I see more questions. Oh, no, I don't. Okay. So I'm going to keep going. So the big one is the change in placement. What do we call a change in placement? It is a change from one place on the continuum to another. So we frequently will see parents that may make the argument, let's say you're moving from a self-contained classroom to a self-contained classroom, and they just happen to be in different elementary schools. Or different, intermediary schools. Those are not changes of placement. That's the placement itself. A self-contained classroom has not changed. The location has changed. So you can change location. The district retains the right of assignment. And so we do that all the time. So you have to be careful about what it exactly is a change in placement. But read it as one change on the continuum to another. You do not need informed consent before certain changes of placement if they are specific to a disciplinary event. So have you gone through your manifestation determination? Have you made it past your manifestation determination? Not a manifestation of the student's disability. You do not need informed consent to change the placement for discipline. The parent can challenge that with an expedited due process, but you still would have the student in a changed placement due to the disciplinary procedures during the pendency of that due process. So you do not need informed consent for that. You do not need informed consent to do a record review. So in those cases where you can't get the parent to do a consent to a reevaluation, if you have done really strong progress monitoring in the 3 years between your last ETR and you have great data and where you have a situation where a lot has not changed, you may do a record review and do an evaluation in that respect without parental consent. All screenings as well do not require parental consent. So what do I mean by screening? A screening is something that is administered to a class wide. So we might be, the MAP testing does not require consent, right? Even though it's an assessment, right? So something that is administered to all children is considered a screening. What about the revocation of consent under procedural safeguards? So a parent or eligible student can revoke parental consent at any time, but they need to do it in writing. And then after that revocation, so, your 18-year-old who does not have a guardianship wants to exit themselves, they can put it in writing. We, again, have to write a very specific prior written notice that will say, we're ceasing to provide these services. These are the services you will no longer receive. This means you don't have the disciplinary protections of the IDEA. And this is an area where we can't use consent override. You cannot file for due process to override the lack of consent here. You can't use mediation. We are going to respect the individual who does this. But remember that that prior written notice that I just told you about that has all those special pieces to it. In the case of a eligible student, so one who's over 18 and not declared incompetent, who is exiting themselves, needs to go to their biological parent as well. That's that paternalistic rule on that record, right, that we talked about. So that has to go to the parent because the parent might still challenge it. And that is, in fact, why that rule exists. All right, so that is parental consent in a nutshell. The next procedural safeguard that I want to talk about are IEEs. One of the biggies, right? An IEE is defined as an evaluation that's conducted by a qualified examiner who's not employed by the district. And not responsible for, the child's education. The parents have the right to one IEE at public expense each time the district conducts an evaluation. So what does that mean? Many times, that means that when we do our ETRs, we want them to be thorough. So, for example, let's say you do an SLD evaluation and you do you do cognitive and academic assessment. And there may be behaviors percolating in the background, right? And we decide that we don't put an FBA or behavioral assessments in the ETR. The parent, we do the ETR and the parent says, I still have concerns. And then we say, well, let's do now an FBA. We now have done 2 evaluations at public expense. That's going to open the door to 2 IEEs parent can disagree with. So it behooves us to be very thorough in our evaluations, right? We would want to roll that FBA into the ETR initially because the parents of the child are entitled to 1 IEE for every ETR done at public expense. So we really want just 1. All right, so what are our responses to an IEE request? If you get a request for an IEE, there are 2 permissible responses under the law. The first is you tell them where they get the IEE. So you give them that criteria, you let them know this is our criteria for doing an IEE. Here's, potential evaluators, but you can pick anyone. And then the other option is to file for due process to defend your ETR. There is no other option. There is no, those are it. And I get that question a lot. So most districts don't want to file to defend their due process. It is going on the offense, taking a parent to due process. And so, we generally say you can never have too much information about a child. An IEE is either going to confirm your ETR testing results, or you're going to gain additional information that discovers something that you didn't know, and you'll program from there, right? But there are only 2 acceptable options, and that is to file for due process to defend your ETR or ensure that an IEE is provided. I'm not done talking about IEEs, but I see questions popping up. So I'm going to pop over to my questions. Oh, we're back on MDRs. The question is, if we have an MDR meeting and the team determines the behavior in question is not a manifestation, the IEP team can decide to change the student's placement based on needs. Well, except there's one thing that's happening in between. So typically what happens is you have an MDR, you find it's not a manifestation, you go into your regular disciplinary procedures. The superintendent, may suspend or expel. And if we're past the 10 days, then the IEP team would come back and change the placement, and you do not need consent for that. That is correct. But we actually have a intervening disciplinary process that has to happen. Typically, it's a superintendent imposing an expulsion. Does the 60-day timeline apply to reevaluations? For example, parental consent is obtained. I have heard mixed things on this. I have always told districts to comply with the 60 days. I have heard that I don't know if this is one of them, the SSTs are like, no, there's nothing that says that. I am going to defer you to your SSTs for that information. The 60 days that exists in the operating standards exists on initial evaluation. Did I say you would or would not want to do the FBA with the ETR? What I said was I would want to make sure that my ETR was comprehensive, because I don't want to do 2 evaluations and open the door to 2 IEEs. So if behavior is percolating or suspected in the background and we're already talking about it, then I might, yes, be looking at that, but it would be very fact dependent. What I said was I would do a very comprehensive evaluation so that I'm not opening the district up to multiple IEEs. Okay, back to IEEs. So when do they have the right to the IEE? They have the right to the IEE when they disagree. So I often get they checked the box that they agreed at the evaluation meeting. They don't get an IEE. Well, if they're coming to you now, chances are they now disagree. People can change their minds. You can ask the parent, with what do you disagree? You check the box, yes. Can I understand with what you disagree now? But you cannot say, well, I'm not going to let you have an IEE because you won't tell me, right? Go back to the last bullet for what I told you, before I took questions. There are 2 acceptable responses to an IEE request. You either file for due process to defend your ETR, or without delay, you ensure that an IEE is provided at public expense. You don't get to ransom it because you don't like that they won't answer your question, right? The fact that they've asked for the IEE does tell you that they disagree. Most parents will say, you didn't do the FBA, or I think that, my child's eligible and you didn't, right? Or they'll usually tell you. It's usually not a secret, right? But it isn't a reason for withholding that. So you can ask, but you may not require the parent to tell you that explanation, and you can't deny it or delay it because of that. There are also parent-initiated evaluations that are not done at public expense that are considered IEEs, right? Because the definition of an IEE is an evaluation by an examiner that is not employed by the district. So yeah, parents can go get their own private IEEs. What do we have to do with those? We have to, if they share the results with us, consider that, right? So if they go get it, even if they didn't ask us to pay for it, we must consider it. They shared it, we consider it, we would decide whether or not it's going to change any of our programming. And of course, once it's shared with us, it may be presented as evidence at a due process hearing. If we're in disagreement and we end up in due process, that is evidence that can now be presented. Notice it says you must agree, you must consider. It does not say you must agree with the recommendations in an IEE. So if the IEE recommends that the child receive 5 hours a day of Orton Gillingham reading intervention 5 days a week, it might be that the district says, I considered that and I rejected that because that's overkill or whatever, right? But you would issue a prior written notice on that. It doesn't mean you have to accept it. The verb is considered by the school district. What if a parent demands an IEE? We share the information with the parent and the parent never follows through. Yeah, well, that's the best. That means you complied and they didn't go get it, right? You told them how to get it. You told them, here's our criteria. and then they didn't do anything. You're off the hook if you get that situation. That's the best of all worlds. How do we proceed if the parent disagrees with the ETR but does not want the IEE? Well, parents are allowed to disagree. You may recall that when I was talking about consent, I indicated it parent does not have to consent to the ETR determination. I know lots of districts that get hung up there. You've identified a student as a student with needs in an ETR, let's assume. Maybe you haven't, but let's assume that you have. You can go forward and put a IEP on the table addressing those needs. They don't have to agree with what's in the ETR. They have to give you consent to do the IEP, but they don't have to agree with it. And if it's the other way, they disagree because of the category, right? They can challenge you in due process. But I always say do not let a parent's disagreement derail your compliance. You still have compliance that you need to move forward with, hypothetically. Okay, so I think I've covered everything for parent-initiated evaluations, and I have referenced in my comments that districts do need criteria for IEEs. Those are usually in board policy. They usually provide a cap on the amount. They might say, the evaluator needs to be within 100 miles and they have to use, standard testing procedures and those types of things. But generally, the requirement is that those criteria need to be using the same criteria your school psychologists are using to complete their ETRs. Okay, so now it is 10:52 and I have you for 40 minutes and we have now come to my favorite procedural safeguard, prior written notice. Number one favorite prior written notice. Why is it my favorite? It is my favorite because I believe it is an opportunity for school districts to tell their story of what they do well, their successes. It's why they became educators, right? We didn't become educators. I became a lawyer. You didn't become an educator because you wanted to get into disputes with parents. You became an educator because you wanted to do things with kids and show them how they could learn, right? And I think prior written notices let us do that. And so, without further ado, let's talk about that. When is it required? It is required when you propose, refuse to initiate or change identification, evaluation, education, placement, or FAPE of a child. Okay, so proposes or refuses any of those four things: identification, evaluation, educational placement, and FAPE. All right, that's a lot. We'll get into that. When you refer a student for an evaluation and when you do a disciplinary change in placement. So that's when it's required. It is not required for a number of things. They're listed in your materials. You can hold an IEP meeting. And and agree that you're not going to do a reevaluation. Don't have to do it. I don't know why you wouldn't document it in a prior written notice, but you don't have to. Those screenings, remember those school-wide or classroom-wide assessments, IAD decisions, before releasing personally identifiable information, with consent. You don't have to give the prior written notice there. Or weirdly, when transferring rights at the age of majority. And that is because it's actually documented on your IEP. But it must be given within a reasonable period of time of the decision to propose or refuse any of those four things, right? And so there is some timing things that you have to consider. Generally, it's got to be given before, right? Hence the word prior. So if you are proposing an IEP on the 364th day of an other IEP, you're going to have to write your prior written notice before the next day, because you've got to get your prior written notice out before you implement those changes that you did in the annual IEP. This is why we don't want to, hold IEP meetings that late in the game, right? There is a specific rule for the timing of a prior written notice. When it's a referral of evaluation, you get 30 days from that date of referral. And I think there's a slide on this, Maya. The timing is also special when we're talking about disciplinary changes in placement. it's got to be prior to that disciplinary change in placement. So again, that manifestation determination is held. We know that the student is going off to, perhaps the superintendent to be, face an expulsion hearing. We're going to have to write our prior written notice before the student is removed into that expulsion. And so that is a specific timing issue there. Okay, what are the components of prior written notice? What are the required components? Well, luckily the State Department has developed a form, and it is super handy because it tracks the operating standards and the IDEA on what is required. So let's pretend you're at an IEP meeting with the parents, Mr. and Mrs. Brown, who surprised you at this meeting with a request that they want to place their socially awkward son, Charlie, who has a diagnosis of autism, at the Daisy Hill private day school. They tell you that the Daisy Hill private day school leads the nation in research related to the therapeutic effects of beagle puppies in the classroom. And the IEP team has to discuss that request at the meeting and decide what they're going to do. They're going to consider recent data and decide if he's going to remain in his current public school setting, or if we're going to consider moving Charlie Brown to the Daisy Hill puppy private day school. So let's take a look at an example in your materials of what the prior written notice might look like. So in the first section, next slide, Maya, you'll see that you have to give a description of the action proposed or refused by the school district, right? And so I frequently am asked to review prior written notices. Can you take a look at my draft, Bondi, of my prior written notice? Sure, I'd be happy to. The number one thing I'm looking for in box 2 is a bunch of sentences that start with the district proposed or the district refused. That's what we're doing here. We're saying what we propose and what we refuse. It's not a long box with the minutes of the meeting. What was proposed and refused. So an example might be the IEP team met to discuss your request to change Charlie's placement. After considering the request, the district is refusing to place Charlie at the Daisy Hill private day school at district expense. End of story. We're refusing, right? The next box is going to tell you why. So it's the explanation of why. Next slide. The agency proposes or refuses to take the action. So here's my example. The IEP team is refusing. These sentences should have because in them, right? The IEP team is refusing to place Charlie at the Daisy Hill private day school because the district can continue to provide Charlie with a free and appropriate public education at his current placement in the district where he's made progress as documented by the data reviewed at the IEP team meeting. This is the box where you get to tell your story. You've been progress monitoring, you've been working your IEP, you've been given the interventions, and you're making progress, right? You have the data to show that. You get to tell your story. You get to celebrate the student's successes. Because if the student wasn't successful, then we might be looking at changing a placement, right? But this district's refusing because they have what they need to show that this student's making reasonable educational progress in the public school setting. So it goes on. The district is also refusing to change the placement because, there's the word again, the Daisy Hill private day school would not offer Charlie the opportunity for interaction with non-disabled peers. They're talking about the LRE requirement, right? He has modeling from non-disabled peers as part of what's going on in his programming. And since Charlie benefits from peer modeling and socialization, and since his IEP addresses communication and socialization with non-disabled peers, the district members, I'm going to come back to that phrase, the district members of the IEP team did not believe the requested placement was appropriate or would constitute the least restrictive environment for Charlie. Okay, so my tip for box 3, I told you that box 2 should have the verbs proposes and refuses. I told you that box 3 should have becauses, right? We're proposing or refusing because, we're proposing or refusing because, right? The other thing that I want to be clear about when I'm drafting a prior written notice is my language, right? So we often will get, those requests to revise a prior written notice. If the phrase is the IEP team determined that they were not going to change Charlie's placement, or because they did not believe the requested placement was appropriate or would constitute the LRE. This is what cross-examination at a due process hearing looks like, right? You as the IS or the special ed director that wrote the prior written notice is up on the stand, and counsel for the parent is saying, you wrote that the district or that the IEP team did not believe that the requested placement was appropriate or would constitute the LRE for Charlie. Yes, I did. Well, is the parent a member of the IEP team? Yes, they are. Did the parent agree that that's not the LRE for Charlie? No. Well, then your prior written notice isn't accurate, right? And so that phrasing, when there is disagreement, that it was the educators or the district members of the IEP team that do something is important. It's difficult unless everyone's in agreement to use that phrase IEP team. So in areas of disagreement, please be careful about the use of that phrasing. Okay, next section on the prior written notice is a description of other options that were considered. All right, so here's my example. The district considered your request for the Daisy Hill private day school because we did, right? But the reasons for rejecting that placement are stated above. The district also considered placing Charlie in the district STACK program, a self-contained program for students with autism. But the district rejected this option because it would not be Charlie's LRE. The district members of the team continue to believe that Charlie's current placement in the regular education classroom with the supports and services he's receiving is appropriate for him. Again, we're celebrating our successes in our programming, right? We get to tell our story, what we're doing well. Next section, what evaluation procedures, assessments, records, or reports we used for a basis of this, okay? So this is an ideal place to include parental participation, right? So in reaching this decision to deny the parent's request for a private placement, the district relied on Charlie's educational records, including but not limited to his current evaluation report, so his ETR, which contains the results of the most recent comprehensive evaluation, his current IEP, his previous IEP. Why? Because I'm guessing that the team sat at the table and said, last year, these were his goals, and we were able to move him here, and this shows progress. He's making progress by looking back at where he was last year and where we're growing to this year and what our progress reporting is. You may have looked back at last year's goals. So that's a great way to show progress, right? Data collected by the staff on Charlie's progress on his IEP goals and objectives. So we're progress monitoring. We're writing good progress monitoring reports so we can use those. Charlie's progress reports and report cards for the past 2 years. Charlie's disciplinary records. Charlie has no discipline. Why? Because he's successful in this placement, right? Charlie's score on regular classroom tests during the past semester in reading and math. And information provided by Mr. and Mrs. Brown. Again, because they're there providing us information. This is a way to document that we are considering the parent and that they're participating in the process, as well as observations and opinions of school staff who work with Charlie. So again, there's a lot that can be put in there because you do a lot, right? There should never be blanks on a prior written notice. This is a chance to tell and celebrate your story, right? What other factors are relevant? That's the last one. This is my catch-all. I am infamous for putting self-serving statements in this section of the prior written notice. So here's my example. Other factors that were relevant to the district's decision include Charlie's progress during the past school year and the district's desire to see that progress continue. Also relevant were statements made by Charlie's parents who were complimentary of school staff. So maybe they came in and said, you know, when parents come in and say, Charlie loves you, Mrs. Smith. He's never been happier, but we really believe that he needs to have puppies during his day, right? I, as a, attendee at a prior or at an IEP meeting, I'm writing those, Charlie loves Mrs. Smith in giant bold letters in my notes because it's going right here, right? In 2 years, when we're still fighting about where Charlie should be placed, the fact that Charlie was successful and happy may be something somebody's forgotten, right? So I'm going to put it here. Um, the services, they were complimentary of the staff who work with Charlie and the services provided to him. Although they explained that they were pleased with Charlie's progress in the current program, they requested the change of placement to maximize Charlie's potential through Beagle therapy provided in the program. Okay, our standard in public education is not to maximize. So when parents say, but that's not the best option, right? Our requirement under the IDEA is to provide an educational program that allows the student to make reasonable educational progress. It's the Buick, not the Cadillac, right? And may be very disturbing to many parents to know that, but when they're looking for the best or the maximization, that's not our legal standard. And so I will document that here in Section 8. Other things that I might put in this section. I might put in there, they brought us a private report and we took the time at the meeting to review it and consider it, right? I might put in there that we requested an opportunity to consult with the private therapist that was recommending Beagle therapy and the parent refused, or we gave them the request and they said they'd think about it, right? Other things I might put here are if I haven't drawn a line in the sand, well, let's collect an additional 6 weeks of data and then come together and reconsider this. I would put that here, right? Because I'm trying to stave off the notion that I've drawn a line in the sand and the only option for the parent is to litigate against us. We requested it. Permission to do additional evaluation. Now we want to do an FBA to see, if, what's causing, maybe they say Charlie's got anxiety and it's causing this and, what can we do about it if we don't use a Beagle puppy? Well, we might want to collect some data on how is the anxiety manifesting in the classroom, right? Or whatever. So this is my self-serving catch-all on prior written notice. So again, let's look at the last one. The procedural safeguards, that's in there. It's required to be there. One thing I will tell you about these procedural safeguards notice here is that it is required to be provided in a language that is understandable to the parent and the general public. So we try not to use a ton of acronyms. And in a language that is understandable to the parent. So if I have a parent that's, only speaks Swahili, I need to make sure that this document is translated. I need to make sure that, it's in Spanish for my Spanish speaking parents, because there's no point in providing someone a procedural safeguard if they don't understand what's in it. And it's our responsibility to make sure that it's in that language that they understand. When there have been recent OCR complaints on this issue. And so I point that out because I have seen some Central Ohio districts get burned by this. So, as I walked through the prior written notice, hopefully you saw that I was using this prior written notice to tell a story about what my educators do and their successes. It is your evidence of compliance. Unlike an IEP, which must be written by consensus, a prior written notice is not written by consensus. It's your document. And that's why I'm a big fan of prior written notice. There are some cases in your materials, they're footnoted in your materials of, do prior written notices get litigated? Yes, they do. And there's some examples of districts that have gotten sideways in prior written notices. For example, the first one is a district who obviously had some boilerplate language that they just put in all prior written notices, and they didn't delete it when they went to do it. And it actually went into a prior written notice that went out to a parent, which ended up being very confusing to the parent, did not accurately reflect what was happening, and they got dinged. They got dinged by the court in that you've got a case in there about, the timing of the issuance of prior written notice after a manifestation determination. I'll let you take a look at that. That's in footnote 145 in your materials. A deficient notice was held to amount to a denial of a parent's right to meaningfully participate in the IEP process. These documents are important in addition to them being a place to celebrate your successes and tell your story about what you do and what, the expertise you've given their child to help them make progress. It's also how they participate. And so in footnote 146, you'll see a case about a court faulting a district for a poor prior written notice that actually didn't make clear to the parent what was happening. So it insufficiently documented the decisions, and it hindered the parent's ability to participate in the process. So, those are in there just as cautionary notes. I have 10 handy strategies for drafting prior written notices because, again, I love prior written notice. So here you go. Let's see. I think we have these on slides, Maya. We hit that one. I'm done with that one. We did that one. Whew. Okay. I have one question before I start with my tips. For a non-contentious IEP meeting, do I recommend a review of each section of the IEP that sections were reviewed or agreed upon, or would you recommend a more general statement of proposed and agreed upon services? Well, so let's say you have a non-contentious IEP, it would be the district proposed a reading and a writing goal and, proposed to keep SDI minutes at a steady level. Why? Because, then in B, or in the third box, I'd be detailing, why do we leave it? Because the level that he's receiving is sufficient for progress. So again, even in the non-contentious, there's a story to tell in your prior written notice about your compliance and your successes. So, all right, tips and strategies for drafting prior written notices. The first is assign someone to take accurate and detailed notes at IEP meetings. I know I live in an ivory tower, and you all are like, I can barely get through my day. And now you want me to find someone to take notes. For the ISs and, directors of special education that are here on the line, what I will tell you is it's very difficult to lead a meeting and really listen to what is being discussed and also take the necessary notes for a good prior written notice at the meeting. So I often suggest maybe having your general educator take detailed notes, or, maybe you have a building secretary or, the one-on-one, someone who can come in and really be the note taker. What should they be listening for? They should be focused on things like parent requests and then the conversation that happens after that, and proposals and the conversation that happens after that. Any information provided by the parents that we didn't have before. Those are areas that are detailed in your materials that I would have note takers paying particular attention to, because those are the pieces of information that help you draft the because statements. That are, so much of the meat of the prior written notice. And obviously the proposals and the requests are things that for each one we need to, consider and either accept or deny. So, a proposed parent, parent requested a one-on-one, right? The district is proposing to add one-on-one supports because, and, or we're refusing because, right? But there's a request for something by the parent. Those requests, the because and data that's discussed after those are very important to capture. The prior written notice is the district's documentation of its determination. Remember, I told you IEPs are consensus, prior written notices are not. This is where we finally take our stand. So unlike an IEP, it's not created by consensus. We ultimately have to make a determination. It is okay to disagree. If we disagree, we need to have reasons for it, right? Which hopefully is supported by data. Avoid leaving blanks on the form. You are only missing an opportunity to show, number one, what you've done, what's been successful, telling your story. There's really no reason to have blanks on an IEP. form. Be sure that each item on the prior written notice is understandable on its own. So don't rely on another piece of information to convey the really important information. You may want to, do a brief summary of it. As a corollary to this, don't use too much abbreviation or acronym. And so for an example, I'm going to read for you something of what not to put in a prior written notice. The IAT proposed a referral after the district provided RTI through an HQT and a para. The district considered ED and OD and OHI due to ADHD and TBI and the sensory data from the OT. The district found no eligibility under the IDEA, but the parent insisted there was a need for an IEP for an FAPE in the LRE. And the district considered the parent's IEE, the district's FBA and BIP, the data collected from our recent PD from the SST on PBIS, and the district also evaluated eligibility under 504 and looked at guidelines from ODE, well, it should be due, that should be updated, DEW, OCR, and training materials from the ESC. Now, all of you got that because you're special educators, but most parents would not. So again, try to avoid the acronyms. Don't complete your prior written notice at the meeting. This is a document, again, that should be thoughtful. And you're going to need to review the notes that were taken. Do I know that districts complete it at the IEP meeting? Yeah, I know. I see it. I'm telling you that's not best practice. Monitor your timelines so that you have the time to write an appropriate prior written notice before you actually have to implement the IEP. Seek assistance when you need it. As you know, there's lots of guidance out there from your SSTs and ESCs. There's lots of people you can go to for questions. Know what to do if the parent disagrees with the prior written notice. We talked about that, right? I disagree with your prior written notice. I need you to amend it. We talked about that today. Know how to prepare the specific prior written notice when someone revokes consent, because as we indicated earlier, there are special components that need to be in that particular prior written notice. They're in your materials. You would continue the services until you issue your prior written notice. But in addition to all the other elements that we talked about for a prior written notice, you also have to include a summary of the educational needs of the child, a summary of the supports and services the child will not receive once those services are revoked, a statement that none of the rights or protections that extend to students with disabilities, such as the disciplinary protections, will extend after the revocation of consent, and that once the prior written notice is issued, the services will cease. And so those, again, are outlined in your materials. And when in doubt, prepare a prior written notice. I don't think you can over prior written notice. I know that, many of you, well, not many of you, but some of you may recall when we didn't have to write a prior written notice if everyone agreed with the IEP, that non-contentious IEP, everyone's in agreement. There used to be a statement on the Ohio forms that said the IEP served as prior written notice. You no longer get that, right? And I actually think that's a good thing. So let's see if I have any questions. I think I've answered all of the questions that have come in. Now, I do have a scenario. I have you for 10 more minutes. I can read through it and we could start to talk through another prior written notice. Or I could take questions, or I could give you back 10 minutes. I'm going to leave that to you all. The SST has so the scenarios in the materials, and then a key to the scenario. So another model prior written notice will be sent to those of you who are registered. And so you will get that either way. So I'll pause here and see if there are any questions, or if anyone pops in the chat and says, that they want to go through it. SST persons, do you have a preference? You do have the prior written notice form draft to go out to attendees, correct?
Yes, we have the one with all of like the suggested responses and whatnot that we're gonna put in the handout link after we're finished.
Okay, all right. Well, I'll read through the scenario and I'll go as far as I can till 11:30, and if people need to pop off, they can. Gerald is a fourth grader who has been receiving assistance in reading in the resource room under an IEP for the past 6 months. Recently, Gerald has been speaking out of turn in class to the point that other children are refusing to sit near him. Gerald's classroom teacher has been sending notes home to Gerald's mother when Gerald is required to stay in from recess due to his behavior, and Gerald's mother is starting to get worried about the increasing frequency of the discipline. Gerald's teacher is concerned that holding him in for recess may actually be making things worse, as now he's getting one-on-one attention from the teacher when everyone else is outside. Mom called Gerald's teacher one day to express her concern, and Gerald overheard them discussing a plan to ignore his outbursts in class so as not to reward his behavior. The next day, when Gerald's teacher ignored him speaking out of turn, he smacked her hard on the back with a ruler. Gerald was suspended for one day, and Mom was sent an email from Gerald's teacher requesting a conference. Just as Gerald's teacher, Mom was sending an email to Gerald's teacher to request it. And Gerald's teacher was picking up the phone to suggest an IEP meeting. At the IEP meeting, Mom requested a one-on-one to provide Gerald with constant behavioral cues to keep him in line with classroom expectations and ensure he did not harm anyone else. The educators on the team, however, suspected that Gerald's behavior was for the purpose of getting attention, and so they proposed conducting an FBA. Mom continued to insist on the aid in addition to the FBA, but the educators on the team were uncomfortable with this proposal because it would provide Gerald with additional attention, which could negatively affect the data. Additionally, they didn't want to single him out in the classroom and socially isolate him further. Mom consented to the FBA, but continued to disagree with the refusal to provide an aid. At the end of the meeting, Mom raised an additional concern. She'd been researching online and read about a special reading methodology she thought would really jumpstart his reading progress, and she wanted that methodology included on the IEP. His special education teacher shared his current data, which showed he was actually progressing faster than expected under the current small group program that he was receiving. After the team reviewed the data, Mom agreed that the proposed reading methodology was not necessary. In fact, the team agreed that based on his progress, they would actually amend the IEP to reduce his time in the resource room by 10 minutes per day. And this change would also give him more time in his classroom before lunch, which would hopefully make the transition easier for him. Mom signed consent for this change. In the end, despite somewhat heated disagreement about the aid, Mom appeared to be happy with the outcome of the IEP and made a comment afterward that she really felt like her concerns had been heard. Okay, so what might my prior written notice look like? So the first thing I'm going to tell you is what box are we checking? At the top of the action, right? The action taken. When you guys get the prior written notice model, sample that we kind of mocked up for this, you're going to see we've checked multiple boxes because we think multiple things are happening here. There's a change in placement. There's the reduction of the minutes. There are some that would argue that that is not a change in placement, that resource room is resource room is resource room. And I will tell you that there's ODE guidance, or has been in the past ODE guidance, that that I have relied on to say that if I'm increasing or decreasing the minutes. There's also some federal guidance out there that says that if you are increasing or reducing a student's access to their gen ed peers, that is a change in their placement. And so for this one, since she agreed to it, I'd call it a change in placement. Those extra 10 minutes that he's getting with his gen ed peers, and she consented to it. So I don't see a problem with checking change in placement. There's a proposal to change the identification, evaluation, or educational placement of the child. Again, we're reducing minutes. We're refusing something. We're refusing part of a mom's requested provision of FAPE, the aid, right? So I'm checking both the proposing and the refusing box. I'm checking reevaluation because I'm going to do an FBA now, right? And I'm going to check the box where there are IEP issues where the parent disagrees with the district. And so I don't think that's a singular. The box can be multiple, right? You can do multiple boxes there. Okay, so a description of the action or proposed or refused. We're proposing an FBA to gather data. We're refusing an aid. We are proposing to change a placement because we are increasing his time with his gen ed peers and reducing his time in the resource room. And we are refusing to change reading methodology. So lots happened at this meeting, right? And each one of those came with the verb proposes or refuse. I also, in the model, you'll see we propose to reconvene the team to consider the results of the FBA. Because again, I don't want the parent angry, so leaving the meeting so angry that they feel like they have no choice but to file for due process. I'm building right in there that we're proposing to come back and look at data, right? And then you'll see there's a description under why in section 3. You know, when we were asked to consider the one-on-one, we believe that his behavior, the educators on the team believe that his behavior appears to be attention-seeking, and that providing him a one-on-one aid could interfere with the results of the FBA and isolate him further. You know, so articulating why, right? The because. Further, there's no evidence that a one-on-one is required for the appropriate to receive a FAPE, and therefore the educators on the IEP team, because this is our area of disagreement, right? So I can't say the full IEP team rejected the one-on-one aid, but agreed to revisit this discussion when the team reconvenes. Again, not drawing the line in the sand for the parent. Then, you know, we go through the reading methodology and why we did not go with the reading methodology. A description of other things that we considered. We considered not doing an FBA because we could have not done that, right? But given the increase in his behavioral difficulties, we believe the behavior data will help us determine whether he needs additional supports. We considered giving him a one-on-one aid, but we gave you the reasons why, right? And we considered changing his reading methodology, and then, you know, why we didn't do that, right? And you can see in the model why we, you know, what we put under each description of information about what the team considered. In section 6, it reads, at the conclusion of the meeting, Gerald's team thanked the educators on the team for considering her concerns. So I'm evidencing that she felt heard, she was participating. Again, this is my self-serving statement, right? And again, that the district is scheduled to reconvene. So that it will be going out to you as another example of a prior written notice. And with that, I've managed to get through everything with 2 minutes to spare. And so I believe if there are no questions, I will let you all have 2 minutes of your day back.